Thanks everyone. This is ROSHINI NAKKA, legal intern at Lawmans. Today, the topic of the video is concepts of condition and warranty under the Sale of Goods Act 1930. To begin with the introduction, the Indian Contract Act 1872, Section 76 to 123, which are present in Chapter 7, are removed and made into a separate act called Sale of Goods Act. This Sale of Goods Act has its roots in the Contract Act 1872. Thus, they are complementary to each other. The Sale of Goods Act is a foundational piece of legislation that provides with the basic rights and obligations of the buyers and sellers. To begin with the introductory sections of conditions and warranty, they are from 11 to 17 of the Sale of Goods Act. Section 11 deals with stipulation of time. Section of the Sale of Goods Act deals with condition and warranty. According to subclause 2 of section 12, the condition is a stipulation essential for the main purpose of the contract, which, if breached, give rise to a right to repudiate the contract itself. For example, if Raja wants to buy a machine which can produce 100 units per an hour, he gives the same information to Ravi to give such machine for him. Now, if Ravi gives a machine which gives only 75 units per hour, this is a breach of the main condition of the contract of sale between them. Thus, there can be repudiation of the contract. Now, let's go with the kinds of conditions. Two kinds of conditions. One, express condition. Two, implied condition. Coming to implied and express conditions, firstly, express conditions are those when two or more persons come into a contract to sell certain goods, they mention certain conditions in the contract itself. These are expressed conditions. Implied conditions are those which do not mention themselves in the contract, but due to the nature or circumstances of such contract, they follow certain conditions. Like section 14 says, there is always an implied condition as to the title of the goods, which means that the goods which are being sold must have the title of the person. He must be the owner of that good and he must have the right to sell that good. On this note, let us talk about the case called Roland versus Devil, in which a car was sold to a person who later, after 6 months, realized that the title of the car was not on the person who sold, that is the seller. So after 6 months, the contract was repudiated and he got back the money. Coming to section 15, which talks about the implied condition as a description of the good sold. Here, the good which is sold based on the description must be in line with the description, and if not, if the condition so was not fulfilled, then the contract can be repudiated. On this note, we can take up the case called Nicole versus Godis, in which the refined rape oil which was brought from abroad was sold, but later they found that they blended other oils in it which is not equal to the description of the goods that they are selling. So after they got the money back. Now coming to section 16 subclause 2, which talks about the repudiation of the contract on the implied condition that the good being sold must be of merchantilable quality. If not, the condition is not being fulfilled and thus the contract can be repudiated. Now coming to section 17, which talks about this good and being sold on sample. So the implied condition as to the sample and the description of the good being sold. If a person gets a good on sample and the sample is not which they got was not matching with the goods that they received, then they can go for cancellation of the contract. For example, if a company is producing certain uniform to certain employees or certain army forces with certain specific mentions to the uniform, and the sample is reaching their all the guidelines, but coming to the original goods that they have produced, they were not producing such goods. So in this case, the contract can be repudiated. Now let us look into a case called Posades versus Spires and Palm. In this case, the plaintiff is an opera singer who will come into contract with the defendant to perform in their opera. Due to her illness, she will not be present at the time of rehearsals. Thus, she is replaced by some other singer. Now she will claim for such contract not to be repudiated, but the court held that the implied condition there being the time to be present the contract is repudiated. Now let us talk about warranties and kinds of warranties. What is a warranty? A warranty is an additional stipulation to the contract which is made by the seller in that contract of sale of good. Now, what are the kinds of warranties? There are two kinds of warranties, like the expressed warranty and implied warranty. In express warranty, the parties will agree to such warranty in the contract of sale of goods. While coming to the implied warranty, there is no such express warranty being made in the contract. Like the warranty of undisturbed possession. According to section 14, subclause B, here it mentions that there is an implied warranty as to the undisturbed possession of the goods that are being sold as per the contract. The second one can be warranty as to the freedom from encumbrances. This is included in section 14 subclause C, which says that there is an implied warranty as the buyer is to be free from any charge or encumbrances to the third party which the buyer is not aware of or not having knowledge of before such contract being implemented. Now there is another thing of this implied warranty, that is implied warranty as to the risky characteristics of the product being sold. That is the potential danger that the good can give. This is also to be given. Now, two important cases in regards to this were Vanity versus Gay, in which the person buys a ticket for a concert, but the concert was in lower standard, so he claims for repudiation of the contract. The court held that it being just a warranty cannot claim for repudiation of the contract, but can claim for damages. Similarly, in Remore and Co. case, when the cotton seeds which are being sold were of a lower standards, the contract cannot be repudiated, but can claim for damages. When will a condition be a warranty? Under section 13 of Sale of Goods Act, there are 3 points. One is when the buyer himself chooses to waive such a condition, it can become a warranty. 2, when there is absence of express or implied term in that effect. 3, when it is legally impossible to be executed. So in these 3 conditions, a condition will become a warranty. Now, what is the difference between a condition and a warranty? 1. Definition. That is, a condition is a stipulation which is the basis of the contract as per section 12 subclause 2. But coming to warranty, a warranty is an additional stipulation to the contract as per section 12 subclause 3. Then let's come to the second point, that is breach. If there is a breach in the condition of the contract can be repudiated. But if there is a breach in the warranty, they can just claim for damages but not for repudiation of the contract. Coming to the point 3, a condition can become warranty under conditions mentioned in section 13. But a warranty cannot become a condition. Now, coming to the conclusion, it is very essential to know the differences between conditions and warranties and what is condition and what is warranty, kinds of it, because buyers and sellers' rights and obligations are connected with it in a commercial transaction. Of course, caveat emptor, that is buyer beware, is very essential for a commercial transaction to be held. But however, conditions of warranties are very essential to be known. Thank you.